where we engage in the highest level of civil discourse on challenging issues we face as a society. I confess we had a minor glitch last year. We had some debate planning interlopers from the Presidential Debate Commission who chose to have their debate on the same night as ours. Even though we had scheduled our debate beforehand, they didn't check with us, but we still had a full house. I assure you that our debate was more civil than theirs was and more informative, but we're delighted that we have your full attention this evening. I want to begin by thanking my colleagues who have worked very hard to plan and implement this evening. Professor Shima Baradaran-Bothman, who is our program chair. Where is Shima? Over there. Thank you, Shima. Professor Paul Cassell in the center, who is our moderator. And I want to give a very special welcome to Professors Jed Rubenfeld and Deborah Turkheimer, who Professor Cassell will introduce more formally in a few minutes. I also want to thank our events team, our IT staff for their technical support, and our development and media staff for their efforts to promote this evening's debate. The Fordham debate has become one of our greatest traditions at the College of Law. It honors one of our former colleagues, the distinguished Dean Jefferson Fordham. He was the Dean of Ohio State and Penn Law Schools for a total of 23 years, a record that I dare say no dean these days would try to match, certainly not me. To Utah's very great fortune, when he stepped down as dean, he joined our faculty for another 2 decades as a presidential professor of law until 1993, a year before his death at the age of 88. So he was still teaching, still inspiring our students well into his 9th decade of life. And indeed, it was our students and a group of recent alums who decided to honor Dean Fordham by conceptualizing and implementing this debate series more than 3 decades ago. I have this wonderful collection of tributes to Dean Fordham, and I found this quote from Dean Sam Thurman, another one of our former colleagues, which I thought was particularly appropriate for this evening and for our time. Jeff has never been hesitant to take public positions on matters of moment, even when those positions were not contemporaneously popular. These issues over the years have ranged from involvement in the Vietnam War to handgun control, to ethics in government, environmental pollution, race relations, civil rights, arms control, the Equal Rights Amendment, and many others. So if we simply substitute the name of one war for another, each and every one of those issues remains relevant today. The issues on which Dean Fordham engaged us and engaged our society are relevant today, issues of critical importance like affirmative consent, even when the positions advocated by someone on one side or the other are not contemporaneously popular, and that is exactly what this debate is all about. In Dean Fordham's own words, "We of the bar must not let great problems of our times concerned with the first order of human values pass us by." So we continue to address issues of great moment, great problems of our time in our annual Fordham debate, and this year is no exception. With that, it is my pleasure to introduce our moderator, my colleague, Professor and former Judge Paul Cassell, who will explain the topic, explain the rules, and introduce our speakers. Professor Cassell.
Thanks, Bob, and let's see, let me just make sure. I think I got mine turned off. So make sure that you have your cell phones turned off so our debate won't be interrupted tonight. We're looking forward to a very exciting 34th edition, I think, of the Fordham debate. And we have a topic that's ripped from the headlines, as we try to do here with our Fordham debate. Sexual assault has been much in the news, and I want to dive right into our topics, but I know that there may be it's possible, for example, today that we might have someone who is concerned about sexual misconduct issues or situation that they've run into here at the University of Utah. I wanted to introduce Sherry Hayashi, I believe. There we are, Sherry. If anybody has any questions after the debate about sexual assault here at the University of Utah, Sherry and her colleagues run our very capable Office of Equal Employment Opportunity. They're responsible for addressing issues of sexual misconduct here on campus. They provide support for students, employees, and others who may have experienced sexual misconduct. And they can provide a series of protective measures such as no contact directives or academic adjustments, even if there isn't any kind of a formal complaint that's moving forward. So if anyone has any questions or concerns about sexual misconduct on campus, feel free to talk to Sherry tonight or contact them at your convenience, and they can discuss options and possibilities with you at that time in a confidential setting. Well, let me say a few words now to help frame the topic we'll be talking about tonight. The idea of affirmative consent has been much in the news lately, but I don't know that there's really been a precise definition given to it, at least in the general public discussion. For example, it's interesting to look at the university setting, and here at the University of Utah, we have what purports to be an affirmative consent policy. We define sexual misconduct here at the University of Utah, and we include certain kinds of behavior, obviously, within that definition of misconduct. And among those is non-consensual sexual contact. Well, what is non-consensual sexual contact? That requires a definition of consent. And here at the University of Utah, we define consent as, quote, affirmative, unambiguous, and voluntary agreement to sexual activity. And so it's interesting that's developed here at the University of Utah. We're not alone in that trend, of course. I think the University of California public system has been very much in the news, and my wife and I actually got to see that in action. One of our daughters attends a public institution out in California, and so my daughter thought it'd be fun to drag her parents along to a frat party. So there we were Saturday, getting dragged into the frat party, and there was a good-looking gentleman in the frat who gave us the consent talk, I guess is what they call it, told us about the 4 pillars of affirmative consent and so forth. So affirmative consent has become, I guess, an institutionalized feature, at least in the public school system out in the University of University of California system. But today we're going to be looking not so much at the educational setting as we are at the criminal law setting. Should we take that idea of affirmative consent that's in educational codes here at the University of Utah and elsewhere and import that into our criminal law? In particular, should we make it a crime to have some sort of sexual contact without affirmative consent? Now, the idea has been much discussed in some very elite legal circles. The American Law Institute, which promulgates the Model Penal Code, a recommended set of criminal procedures that have proven to be very influential around the country, has been looking at reforming and updating its provisions dealing with sexual assault. And reformists have proposed adding an affirmative consent provision into the Model Penal Code. And that's been the subject of some controversy as well. Reformers say this would be a good idea, help to expand the boundaries of sexual autonomy. Critics argue that it's poorly defined and would have other problems. And that's why we brought 2 of the country's leading experts here on affirmative consent to help shed some light on those issues. I could spend a good deal of time singing the praises of both of our speakers, but you've had a chance to read the program, so I will just say we are pleased to have tonight Professor Deborah Turkheimer, who is the class of 1940 Research Professor of Law at Northwestern Law School. We're also pleased to have Professor Judd Rubenfeld, who's the Robert R. Slaughter Professor of Law at Yale Law School. Our format for tonight's debate is typical debate format. Typically, the affirmative, that is, the proponent of change, goes first, and we've identified Professor Turkheimer as perhaps being the affirmative, although she may have a few words to say about that. And then Professor Rosenfeld will respond. Professor Rubenfeld will respond after that. And then they'll have a short reply and response. And then we'll have, I think, a very interesting feature. We have up here on our screen a website that I'd ask you to log into if you're interested on your cell phone. If you go to, Slido.com, you will find a website there, and if you enter hashtag 8160, you can ask a question And the question will then be fed through the miracles of modern technology up to my screen. And that'll give me a chance to try to identify some good questions that should be asked to our speakers. In fact, I think you can help in good Facebook fashion or whatever. You can like a question, and that I think somehow raises its prominence on the list. I don't know. Is there a dislike feature? I don't know if you can drive something down if you think it's a bad question. But in any event, I'll be up there trying to sift through the questions, trying to identify the best ones that'll be of greatest interest to a general audience. So feel free to do that. At any point in the program, maybe you'll want to hear what our speakers have to say first. So they're each going to speak for about 20 minutes, and then we'll start a little bit of back and forth and start taking some questions. So without further ado, I'm going to turn the time over to Professor Turkheimer.
Well, first I want to thank the College of Law and Professor Cassell for the kind invitation to participate in this debate. I'm very happy to be here and to share the stage with Professor Rubenfeld. Let me begin with a story that's sadly familiar. Antonio and Deanna were college students who had just met through mutual friends. On the night of the incident, they spent the evening studying and playing cards in a student lounge because Deanna had stayed awake the night before to complete an English paper. She was especially tired. Around 2 a.m., she fell asleep on a couch. She was face down on her stomach. At some point in the night, she was awakened by the sensation of a man on her back, and she simultaneously became aware that her pants and underwear had been pulled down to her thighs and her bra was unhooked. She could feel the man's penis against her buttocks. She pushed him off, stood up, and saw that his pants and shorts were pulled down. She recognized Antonio. Did Deanna consent to sexual contact by Antonio? The answer, I argue, is obvious. She did not. She said nothing and she did nothing whatsoever to indicate her willingness to engage in sexual activity. She was inert, she was passive, and this should not constitute legal consent. In other words, the law should reject the idea that because Deanna did not resist physically and because she did not say no, she consented. Instead, the law should embrace a standard of consent that is affirmative, meaning that some indication, any indication, verbal or nonverbal, of a willingness to participate in sexual activity is required. Affirmative consent is now a familiar standard on college campuses, including the University of Utah, yet the criminal law lags behind. Among states that define consent, most still require that a victim demonstrate unwillingness to engage in sexual conduct, that is, to resist verbally or physically. In these states, without consent means without an expression of non-consent. Absent such an indication, someone who's remained inert, someone who's remained passive throughout the entire encounter, someone like Deanna, is said to have consented to it. By way of contrast, affirmative consent definitions transform the legal meaning of passivity. Absent an expression of consent, an alleged victim is deemed not to have consented. To be clear, and this is important, affirmative consent need not be verbally expressed, and it may be implied. Also important to bear in mind is that in affirmative consent jurisdictions, the burden of proving guilt beyond a reasonable doubt remains on the state. In order to convict, the prosecution must demonstrate that the defendant engaged in sexual activity without the alleged victim's consent, which must be manifested, again, in an affirmative manner. So why should affirmative consent be the law? Modern rape reform has for decades been moving away from the archaic notion that rape law exists to protect a woman's chastity. That was the traditional rationale. The new rationale, I suggest, ought to be that rape law protects sexual agency. Sex without consent destroys sexual agency. Indeed, sex against one's will is sexual agency's opposite. If rape is a violation of sexual agency, sex with a non-consenting, sleeping woman is akin to sex with an object. The woman is acted upon. Defining consent as words or actions indicating freely given agreement recognizes that women, like men, are sexual subjects, not objects. Women, like men, are capable of having and capable of expressing a willingness to engage in sexual conduct. Without somehow expressing this willingness, one cannot be said to have acted as a subject. In short, affirmative consent definitions have the greatest potential to promote agency. Well, yes, say some opponents, but should affirmative consent be incorporated into the criminal law? Many who support affirmative consent as a rule of personal conduct balk at incorporating this norm into a binding code, particularly a criminal code. Some worry about the prospect of miscommunication in sexual interactions, which are often portrayed as inevitably confusing and ambiguous. Others reject the premise that sex is hopelessly opaque, but nevertheless despair of specifying with enough precision what constitutes consent. If the criminal law were to adopt an affirmative consent requirement, critics charge, unjust prosecutions would or could result. I wondered about this concern, so I decided to do some legal research, which resulted in a paper published last year. The paper takes a close look at those jurisdictions that have already adopted affirmative consent jurisdictions in their criminal code, because, as it happens, the move to affirmative consent is not quite as radical as opponents have presumed. A handful of states have actually adopted affirmative consent definitions already. For instance, in Wisconsin, consent means words or overt actions indicating a freely given agreement to have sexual intercourse or sexual contact. In Vermont, consent means words or actions by a person indicating a voluntary agreement to engage in a sexual act. And in New Jersey, consent requires permission to engage in sexual penetration that must be affirmative and it must be given freely. In these few states that have already adopted affirmative consent requirements, an experiment, one that's quite useful for present purposes actually, this experiment has been underway for many years now. A survey of the case law in these jurisdictions reveals a number of recurring fact patterns, which can be classified under the rubrics of sleep, intoxication, and fear. I found that in none of these categories are the cases characterized by mixed signals. So let me briefly describe each category just to give you some sense of what affirmative consent, or more accurately, its absence, looks like in practice, and why it is the right standard for criminal law. First, sleep. So the sleep cases fall in a continuum. At one end, the victim is asleep throughout the sexual encounter, meaning she has no opportunity to communicate in a way that could possibly be misinterpreted. At the other end of the spectrum, the victim awakens relatively early on, allowing her, in theory, to convey her willingness or unwillingness to engage in sexual activities. The case I described when I began, involving Deanna awakening to Antonio's contact, well, that's a case that went to trial. Antonio mostly agreed with Deanna's version of events. According to his account, he was well aware that Deanna was sleeping on her stomach on the couch, but he believed that at some point she awoke and was pretending to be asleep, since, as he put it, women pretend to be asleep. I guess it's a trick to get guys to do foreplay. To be clear, this impression was not based on any conduct or communication on Deanna's part. Antonio did not even claim that Deanna sent mixed signals, and she was, by all objective measures, inert throughout the entire encounter. Because this occurred in Wisconsin, which is among the few states to have adopted an affirmative consent definition, the court could affirm the jury's finding that Deanna did not provide freely given agreement to engage in sexual contact. So the affirmative consent standard relieved her of the burden of expressing her lack of consent while in a dead sleep. Without an affirmative consent standard, however, she would indeed be required to somehow express a lack of consent, and this is not an acceptable result. Let me say a little bit about intoxication. The intoxication cases range between total incapacitation and impairment that is severe but not complete. At one extreme, unconsciousness, intoxication completely destroys the capacity to communicate. In these cases, there can be no real concern for mixed signals or confusion. At the other end of the continuum, extreme intoxication raises the question of what, if anything, the alleged victim was able to convey with regard to her willingness to engage in sexual activities. A New Jersey case illustrates this dynamic. The victim, M.R., was a high school senior at the time of the incident. On her first day of work as an office assistant, she met the defendant, who invited her to lunch after instructing her not to let their manager know that she was leaving with him. Once they arrived at their destination, which MR came to realize was a bar, the defendant ordered drinks for two. After an hour, MR became dizzy and nauseous. She went to the bathroom and vomited. When she returned to the bar, the defendant took her to a dark back room, at which point he sat her in a chair, began kissing her, and removed her pants and underwear. As the court emphasized, MR told the defendant no, but could not physically resist. The defendant ignored her pleas, picked her up from the chair, and penetrated her. Now, clearly, MR's level of intoxication impaired her ability to physically resist the attack. As she would later explain, I didn't know what to think. It just felt kind of like it was a blur at the moment. I didn't know what was going on. And on top of that, I see him doing these things, but then I can't seem to respond with my body to what's going on. She managed somehow to express her unwillingness to engage in intercourse, as evidenced by her no's. But even if she hadn't said no, as is so often the case with extreme intoxication, her passivity would not mean that she was consenting to intercourse, as affirmative consent standards properly affirm. The last category involves fear. To understand what these cases entail, consider a New Jersey case called State versus Lederer. The victim, referred to in the opinion as the prosecutrix, was acquainted with the defendant and agreed to inspect a rental property with him. Here's how the court described what happened. At the home, defendant began to disrobe the prosecutrix. The prosecutrix objected and pushed defendant's hand away. The defendant allegedly told her it'd be worse if she fought. She then permitted the defendant to disrobe her, and the defendant performed an act of intercourse. As the court emphasized, because again, New Jersey is one of the few states that has adopted an affirmative consent standard, whether or not she verbally protested, it should be clear there was no consent to intercourse. Finally, I should add that several cases in the fear category involve fright that arises not from physical violence, but from a surprise attack. These cases, which have been described as involving quote-unquote passive failure to cooperate, frequently involve young, trusting victims. For instance, the victim in State versus Benitez, a girl called J.R., was 17 years old. The defendant in his 40s was the husband of J.R.'s church pastor. On the night in question, following a church event, the defendant offered to drive JR and the other youths to their homes. After dropping off everyone but JR, the defendant drove in the opposite direction from her house and stopped on a dead-end street. He then began to rub the inside of her thighs, kissed and bit her neck, put his hands under her shirt, and rubbed her breasts. The court tellingly observed that at first JR was so frightened that she could not speak. Because she experienced an egregious violation of trust, which was likely compounded by her youth and a significant age differential, JR was afraid and she froze. She did not specifically indicate that she was unwilling to engage in sexual contact. Nevertheless, because the case arose in an affirmative consent jurisdiction, she was deemed not to have consented. This is exactly the right result, and it shows what an affirmative consent standard can do to modernize the law of rape. To summarize then, in cases involving sleep, intoxication, and fear, where we often, though not always, see passivity, a requirement of affirmative consent formalizes an understanding that is or is becoming uncontroversial. A victim who is unconscious, sleeping, or immobilized by fright does not consent to intercourse, simply by virtue of not resisting. Miscommunication is far less of a concern than affirmative consent opponents have suggested. That said, the criminal law can and should allow for the possibility. In those cases where a plausible claim of mistake arises, the question is one of reasonableness. As a general rule, a person is not guilty of rape if he possessed a genuine and reasonable belief in consent. This means that where a defendant is actually confused, the criminal law has an outlet for the jury to evaluate whether this confusion is justified. This, I argue, is the proper framework for resolving questions of responsibility and blameworthiness. I'll conclude by bringing us to the present post-Harvey Weinstein moment. Among the 100+ allegations of sexual abuse that have publicly surfaced against Weinstein in the past month, one woman came forward and reported the incident to law enforcement officials soon after she was abused. In 2015, Ambra Battalana, an Italian model, promptly told New York police officers that Weinstein had grabbed her breasts after asking if they were real. After investigation, prosecutors determined that a case was not provable and declined to bring charges, notwithstanding a recorded conversation in which Weinstein admitted touching Battalana's breasts. "I'm used to that," he said, and indeed, from what we now know, he was. Battalana was caught by surprise, and she was afraid. To be clear, she did not say no. To be clear, she did not consent. This is because a woman's breasts are not simply there for the touching, nor are women simply objects to be penetrated, absent some indication to the contrary. Affirmative consent standards make these truths abundantly clear. They send a message that is more important than ever as we as a society both grapple with the prevalence of sexual violence and strive for greater gender equality. The old law of rape is mired in retrograde assumptions about women's sexual availability. By recognizing a crime of engaging in sexual activity without affirmative consent, we can move forward. Thanks.
Professor Rubenfeld will now provide a response.
Dean Adler, thank you so much. And Professor Cassell, thank you for having us here. And Professor Turkheimer, I want to thank you too. I agree with so much of what you said and so many of the remarks, and I want to thank everybody who's here tonight for coming. We do disagree, though, pretty seriously. So I want to try to explain why that is. Sexual assault's a terrible problem all over the country. on college campuses and elsewhere. And the question is affirmative consent part of the solution, part of the answer to it? And I don't think it is. And I want to try to explain to you why I have these reservations about it. I need to begin, though, by telling you something about cases of when women or men are asleep and someone takes sexual advantage of them and penetrates them. I want you to understand very clearly that's rape in every state in the country. It doesn't matter whether these states have the new affirmative consent measures, whether you're in one of those few states or whether you're in all the other states. That's rape. It's rape everywhere. So I don't think it's fair to say that, so if anybody's thinking, obviously that's got to be rape, so we've got to have affirmative consent measures, that's not how it works. That's already rape. We don't need affirmative consent measures to make that rape. It's rape everywhere. And a little later, at the end of my remarks, I'll explain to you why I think it's of course the right result, but why it's the result under current law and not why we don't need affirmative consent measures to get there. Now, why do I think there's something wrong with affirmative consent measures? I'm going to begin with a case. It's a case from a college campus. We have a lot of experience with affirmative consent measures from college campuses. It's not just the University of Utah and the Public University of California. 1,400 college campuses all over the country have adopted affirmative consent measures. We have a lot of experience with it. In the state of California, every college and university has to adopt that by state statute. Same in Connecticut, same in New York. So we have a lot of experience with these measures. So these are affirmative consent-based measures of sexual assault. That's what I'm talking about. I'm going to start with a case. So Jane and John are a longtime girlfriend and boyfriend. They're college seniors. And one morning, Jane kisses the sleeping John goodbye. She gets up earlier than he does. She's going off to class, and she kisses him goodbye. But he's asleep. Did he affirmatively consent? No, he didn't. At Yale and at about 1,000 college campuses all over the country, affirmative consent is defined as follows: positive, unambiguous consent, just like it is here at the University of Utah. Was there positive consent? No. Was there unambiguous consent? No. If you're thinking, well, maybe because of the past of their relationship, he did consent. No. Every affirmative consent measure is written so that past consent does not imply you can't get from there to affirmative consent. And moreover, they say very specifically, affirmative consent cannot be given by somebody who's asleep. So it's clear cut. There was sexual contact and no affirmative consent. And I wrote in an article 3 years ago when Yale first adopted its measures, and these measures were being adopted all over the country, that case was going to be a case of sexual assault. And everybody, all the proponents of affirmative consent said, oh, that's ridiculous. No one would ever claim to be assaulted. No one would ever bring the case. No prosecutor, if we moved to criminal law, would ever bring the case. Nobody would ever complain of it. It just won't happen. My own students said that. That was a very sad day for me when law students were arguing that way, because that's not how you evaluate a definition of a crime or a serious offense in the law by saying nobody will ever bring it. You got to ask, is it getting the definition right? If that's not sexual assault, we should not be defining it as sexual assault. It means there's something wrong with the definition. Last year, 2016, a guy at Brandeis was found guilty of sexual violence because he kissed his sleeping boyfriend awake. It happened just as I had said it would in my article, and he was found guilty because of an affirmative consent measure. It was a straightforward application, had to be found guilty of sexual violence or sexual assault. How many people, I'm just interested, how many people think that in that case there's a sexual assault? I'm going to guess that almost nobody thinks that's a sexual assault. It's a pretty minority opinion to think that's sexual assault. Most people don't. That's sexual assault under an affirmative consent measure. That's a problem. That's a problem. What is it, though, that affirmative consent measures get wrong? What's the exact mistake? What's the mistake they're making? That's not easy to put your finger on, because there's so much good sense in affirmative consent measures. You know, something that Professor Turkheimer could have said, it's like if you're going to use somebody's cell phone, you're not going to use it unless they give you their affirmative consent. Why shouldn't we have the same standard that we would have when you use somebody's cell phone? Why should we have that same standard for sexual relations? There's so much good that it can do, and it makes so much sense in so many ways, but it's getting something wrong. What is it getting wrong? To try to understand that, I got to give you a trickier case, much harder than the first one. So in this case, instead of John and Jane, there's going to be Charlie and Ashley. Now, it's not their real names, but this is a real case. I got involved in this case. I represented one of the parties. And here's what happened. One night, and Charlie and Ashley, college juniors, and they'd been in a long-time relationship, off and on. Charlie texts Ashley and says, "Can I come over to your place to hang out?" And Ashley texts back, "No, not tonight. I've got a really big midterm tomorrow morning at 8. I got to study." And Charlie writes back, "Just a few minutes." And Ashley writes back, "Not tonight." And Charlie writes back, "Please." And Ashley writes back, "Okay, just a few minutes, but I don't want to do anything." Charlie goes to Ashley's place, and despite that text, "I don't want to do anything," there is consensual kissing. But everybody agrees it's consensual kissing between them. But after some consensual kissing, Ashley says, "I really have to study. I don't want to do anything else." And at this point, Charlie gets very angry and says, "Why not? I think someone told me that you've been seeing someone else. I think you've been sleeping with someone else. Have you been sleeping with someone else?" Ashley admits it and says that Ashley has been sleeping with someone else. And Charlie gets furious and is angry and yells, "How dare you? I thought we had an exclusive relationship," and is screaming and yelling. And Ashley says, "I can't do this right now. I can't do this. I have to study. I'm going to my room." Ashley goes to the bedroom, shuts the door, gets undressed and gets into bed. Charlie does not leave. Charlie follows Ashley into the bedroom, opens the door. Charlie is now crying but still angry. Says, "I can't believe you did this to me." Ashley says, raising the blanket, do you just want to have sex now?" And Ashley will later say at the hearing that Ashley said this because it was going to be the only way to get rid of Charlie. Charlie, still crying, gets into bed, and they have sex. The hearing panel will find that there was no force, no threats, and that all the action was voluntary. Do you think that I have described, how many people think I have described a case of sexual assault? How many people think that is not a case of sexual assault? Because there's more of a mix here. About half of you thought there was, half of those who raised their hands thought there was, about half of those who raised their hands thought there wasn't. The hearing panel found that there was sexual assault in the case. But here's something that I doubt very much that anybody in this room would have thought. Ashley was found to have committed the sexual assault. Ashley, not Charlie. Because I didn't mention that Ashley was a guy and Charlie was a female. So now you have to recalibrate the story, but change the genders. It all happened just the way I described. But Ashley is the guy in the bed, and he is found to have sexually assaulted Charlie, who gets into bed. And the hearing panel will find, even though the action was all found to be voluntary, that there wasn't unambiguous affirmative consent, citing some material that the college had handed out saying that if someone complies with sexual requests but is crying while they do it, that's not unambiguous affirmative consent. And so sexual assault was found. Now, is there possibly something funny, a little double standard going on here? Because if you switch the genders the way I did, I bet nobody thought that Ashley could possibly have been guilty of sexual assault in that case. Although maybe I didn't ask you, did some of you think that? But with the genders the way they were, this hearing panel unanimously found that Ashley had committed sexual assault. But I'm not interested in the possible gender stuff that might be going, possible double standard. That's not what I'm trying to draw attention to. What I'm trying to draw attention to is the finding by the hearing panel that all the action, all the sexual activity, all the sexual contact in the case had been voluntary. The hearing panel said so in its report. But affirmative consent had not been given, hence there was a sexual assault. And this, I want to suggest to you, is what affirmative consent measures get wrong. What's the function of consent in our law? Consent is used all over the criminal law as well as civil law, tort law. It's used for theft. Someone takes your property without your consent. That's what theft is. It's used for trespass. Someone comes into your house without your consent. That's what trespass is. Consent is used everywhere in the law. If two people are boxing, it's not, an assault and battery because they consented. What is the function of consent? What are we trying to test when we test for consent? For hundreds of years, in all these areas of law, what we've been trying to test, what we should have been trying to test at least, when we ask whether people consented, we should be asking whether they were doing something voluntary. That's the whole function of consent. That's the point of consent. It's a proxy for voluntariness. We want to know whether it was done, whether the thing was done voluntarily or against their will. That's what we want to know. But if you define consent in certain ways, in certain contexts, you're going to split apart consent from voluntariness. You're going to pry them apart. They're going to come apart, and when they do, something goes wrong. Because assault means something involuntary, something happened against your will. That's what an assault is. That's what it is. And if you have situations where people engaged in activity totally voluntarily, people have sexual relations voluntarily all the time. People, whether they're married or they're a long time in a relationship, and they do not express affirmative consent in a clear way. People do this all the time. They don't say anything or do anything that's a clear, unambiguous indication of affirmative consent. Are we going to say in all those cases that a sexual assault has taken place? What you'd be saying is that each of them sexually assaulted the other. I don't think we should tolerate, I don't think we can deal with that result. I don't think that's the right result. But that is the result that follows from an affirmative consent measure when it's defined in such a way as affirmative consent measures do, so that voluntariness and consent come apart. Now, I said at the beginning that I would come back and tell you why those penetration with someone who's unconscious cases are so easy, why you don't need affirmative consent for that. Because that's happening against somebody's will. That's having sex with someone against their will when they're unconscious. It's not voluntary. That's why it's such an easy case. Of course that's sexual assault. Of course it's rape. You don't need a special affirmative consent measure. Affirmative consent measures very often track voluntariness. Very often when someone gives affirmative consent, it is voluntary. When someone gives affirmative consent, by the way, you can't always be sure that a yes isn't coerced. Someone could say yes at gunpoint. That should not be, they've affirmatively consented and they've done so clearly. That should be a sexual assault because it wasn't voluntary. It's not the affirmative clear yes that turns it into not a sexual assault. It's the involuntariness despite the yes, the coercion that makes it a sexual assault. So, I will just conclude by saying we have a bad problem all over the country Professor Turkheimer is absolutely right to bring up Harvey Weinstein in this conversation. It's just disgusting and hideous what way too many men do, and we have a terrible problem of sexual assault. Is affirmative consent part of the answer to it? If what I have said to you is true, then affirmative consent measures see sexual assault when there is no sexual assault in some cases. And they don't help us deter the real problem of sexual assault in America and on college campuses, because the guys who are committing real sexual assault, both on men and on women, they're not asking. They're not the ones politely asking. So it sees sexual assault where there sometimes isn't sexual assault, and it doesn't deter the real sexual assailants out there. That's what I'd like you to remember, and I look forward to your questions.
We'll now have a response from Professor Turkheimer.
Just very briefly, because I'm also looking forward to your questions. I absolutely agree with Professor Rubenfeld that a yes at gunpoint is not consent. And I think that the affirmative consent standards obviously address that by noting that this is freely given and it's voluntary. And so that's a case where it's an extreme formulation, but there is no consent there. Second, people do it all the time without affirmative consent. You know, it's an empirical question, and I don't know that any of us is fully equipped to sort of know what is happening out there in the world. That said, my sense is that the consent revolution has really taken hold on college campuses. We have a generation of folks coming up in an age where affirmative consent is the rule, has been the rule, and I think that that's further reason to believe that this is a widely shared consensus about how people behave and how people ought to behave in matters of sexual encounters. And then the last point I'll mention goes to the scenario involving a kiss on the lips. And I would just note that criminal law codes tend to diverge from campus codes insofar as the prohibited conduct is somewhat narrower. So most jurisdictions, in their definition of what falls under the category of sexual contact for purposes of these provisions, include genitals, the anus, the breasts, but the kind of lip-on-lip kiss that was described would tend not to fall within that criminal law definition. And so I think when we're thinking about affirmative consent, we're also thinking about what it is that must be consented to. Penetration, clearly, certain kinds of sexual contact with certain parts of the body. Thanks.
All right, we'll have, if Professor Rubenfeld wants a short reply, but let me just give a brief commercial interruption here. This is a good time to start sending those questions in. Again, all you need to do is go to this website on your smartphone, and then if you enter the code 8160, there's already a hashtag in front of that, so just put that number in and it'll give you an opportunity to send a question. And then the question will come to my screen here, and I'll try to pick out which questions seem of most interest to everyone and feed those to our speakers. But let me give the last word here to Professor Rubenfeld, and then I'll start asking the tough questions to our debaters here.
Thanks. I just wanted to say 30 seconds. Actually, Professor Turkheimer is more expert on the following than I am, but as she knows, in fact, it was a proposal made by a very important legal organization, the ALI, to reform the model penal code, which lots of states consider so influential. They grab hold of what is said in the model penal code and they change their laws on its basis. The proposal was just made last year to change the model penal code to include a crime of any sexual contact without affirmative consent, not limited to the kinds of contacts that Professor Turkheimer was describing, but one that would have included just two people coming out of a movie theater and holding hands with each other, and certainly the kiss that I described. And by the way, there was resistance to it from the people like me who are not in favor of affirmative consent measures, so it has not been enacted to date, but it's very much on the table.
All right, well, we're getting lots of questions in, and let me throw the first question over to Professor Turkheimer, which seems to revolve around your scenario of Deanna and Antonio, and one of our audience members is writing in, if consent can be given by nonverbal conduct, how can the law create an objective standard? How, for example, in the illustration you gave, how could one prove or disprove whether nonverbal consent was given before? How would the proof of this affirmative consent or lack of affirmative consent, how would that play out?
Well, it's a great question, and I think we can't talk about these kinds of cases without talking about proof and without thinking about credibility. These are often described as he said, she said cases or word on word cases, and it's true that in any case of sexual assault, the credibility of the complainant or alleged victim is going to matter a whole lot. There's often corroborating evidence when a case comes forward to trial, so it's actually not just her word, or in the case of a male victim, his word. But absolutely, the credibility of this person who alleges having been assaulted is going to be the key issue for the trier of fact if the case comes to trial, a jury. That's true whether an affirmative consent standard is in place or not, right? And so credibility matters regardless of whether the law defines consent in affirmative terms or whether the law requires a victim to resist verbally or physically. So, I think we should be talking about credibility and how credibility is assessed. I think we should talk about the importance of corroborating evidence, but be very clear about the fact that in any case involving a scenario where consent is an issue, however consent is defined, the credibility of the victim or alleged victim is critical.
All right, unless there's a response to that, I've got a question now from the audience for Professor Rubenfeld. This audience member asks, let's see, in America today, only a low percentage, probably in the single digits, of sexual assaults are reported or certainly successfully prosecuted. Wouldn't affirmative consent increase the reporting and prosecution rates and be a desirable thing for that reason?
That's a great question. Is this on? Can you hear me? That's a great question. We have a huge under-reporting problem for sexual assault, and a lot of people, including myself, are racking their brains trying to figure out ways to improve that problem. For example, as I've written, we have to reform our police practices to begin with. We have to get in there, and it can't be the case that people going in to report sexual assault are grilled and treated with suspicion, and that happens all too often. And I suspect that that's a big part of the reason why a lot of victims don't report. Now, the question, though, that was asked was, wouldn't affirmative consent measure, wouldn't it help with the under-reporting problem? Well, here's the problem. It might make a lot more sexual assault reportable. It might. I'm not really sure that it's going to help with all the problems of that keep women from reporting sexual assault to the police, but it's going to turn a lot of things into sexual assault that aren't assault. That's what I've been saying to you. Imagine two people who are voluntarily having sex, but neither one of them affirmatively consented, neither one of them gave clear affirmative consent. Are we really prepared to say that, are we really prepared? Okay, maybe it's going to make a lot more sexual assault reportable, but a lot of those sexual assaults are going to be cases of voluntary sexual activity. And that would be, I think, a terrible result.
All right, now I have another question for Professor Turkheimer. Unless you have a response to that. No.
Well, I wanted to agree that police practices are a real problem in this area, and that when we're thinking about rape law reform, we should be thinking about changing the substantive law of rape, which is what we're mostly focused on today. But we should also be thinking about law enforcement practices and eliminating gender biases in the policing and prosecuting of sexual violence. So that's important to say. I do, though, believe that moving to affirmative consent would somewhat address the underreporting problem in this sense. Rather than have police officers, prosecutors, and jurors ask the question, what did she do to resist? Right, and to look at what she did or didn't do to indicate no, the framework changes, and I think that is a framework more conducive to victims of sexual violence coming forward.
I just wanted to say one thing about Professor Turkheimer is absolutely right that some courts in some states still inquire whether the victim resisted. I want everyone to understand, though. The old requirements of utmost resistance are gone. They've been completely abolished. Not a single state in the country has that kind of requirement anymore. And many states don't look There's no resistance requirement anymore. It's certainly no part of my view that there should be any resistance requirement in every state in the country. If the accused has put the victim in fear, no court in this country is going to demand any resistance. I don't think Professor Turkheimer will disagree with this. No court in this country is going to demand that the woman or the victim in that kind of case say no. This was the third category of the kind of case that Professor Turkheimer had listed to you, cases of fear. And she was arguing that in cases of fear, it should be recognized as rape or sexual assault, even if the person doesn't say no, because they're afraid. But that's already the law. That's already the law. If the accused has put the victim in fear, there's no requirement the person say no or resist in fear of bodily harm, at least in any state that I know of in the country. Professor Turkheimer, am I wrong about that?
So when I see resistance, I am also contemplating the kind of verbal resistance, the requirement of indicating non-consent. And so resistance is not what it used to be at common law. I absolutely agree. But there's still this requirement in jurisdictions that have not adopted affirmative consent rules that the alleged victim do something to indicate unwillingness. And that's what I think of as sort of the modern resistance requirement.
But not if the victim is in fear, not if the accused has put the victim in fear, certainly in fear of bodily harm. There's no requirement of a no.
So the fear cases are tough when the defendant's actions to put the victim in fear took place not immediately before the intercourse. And so what I worry about are the cases involving what courts think of as sort of past abuse, things that happened in the quote-unquote past that don't seem close enough to the incident in question to count as the kind of force that Professor Rubenfeld is talking about. And in those cases, these are tough cases for the traditional law of rape.
All right, I think my next question is for Professor Turkheimer, and I think I'm surmising here, but I think I see one of our first-year law students wondering about this. Here's the question. If affirmative consent is adopted, will courts look to contract law to resolve the formation of consent? Will they look to issues like duress, adhesion, and some of the other things that I think some of our students will be learning about in the first-year curriculum?
That's an interesting question. It has not happened in the jurisdictions that are these affirmative consent jurisdictions that I've looked at. So thus far, contract law has not migrated to criminal law in the way that the questioner suggests might happen. And I think that there's probably good reason for that, right? To think about affirmative consent in the context of sexual relations differently from how we might think about contracting. There may be principles that we should think about sort of loosely importing, but I don't think you're going to see sort of a direct drawing from the law of contract into this context.
Well, it's a great question. It's difficult to know. I would think probably there would be some movement toward greater formalization. If you really did put affirmative consent into criminal law and people were really being prosecuted for it, the next step will be, the law will have to start articulating certain steps people can take, either words they use or actions they take that count, and give people a safe harbor so that they know that they won't be prosecuted. And you'd probably see some movement toward formalization, although, I don't think we've seen that yet in the states that you mentioned. But I think it's a good question. Something like that might happen.
All right, I think this question is for Professor Rubenfeld. Would prosecutorial discretion weed out some of the ridiculous results that you alluded to? And let me just add on to that question an issue that I'm wondering about. The kiss on the lips scenario is a troubling one. I'm wondering if that could be resolved by saying that the sexual contact that would be involved would require for purposes of sexual gratification as opposed to something else.
Okay, two very different questions. So that's what people say who are advocates of affirmative consent measures in criminal law. They say, don't worry, Professor Rubenfeld, about any of the cases that you brought to our attention. Prosecutorial discretion will handle all of that. And my reply to that is just what I was saying a few minutes ago. if you all agree with me that those are not cases of sexual assault, then there is something wrong with defining sexual assault that way. That is not how the criminal law is supposed to work, that it throws this giant net and defines as criminal offenses all of these things that aren't criminal offenses, and then you say, okay, prosecutorial discretion will come in. And we're not talking about jaywalking here, we're talking about sexual assault. People get marked for life as sexual offenders. If they get convicted of one of these crimes, this is a very serious stigma. This is a very serious kind of offense to talk about and define too broadly, and to then say prosecutorial discretion is going to come in and save us. So that concludes my answer to that question. The other question was about, well, wait, couldn't we define sexual contact a little differently in such a way that a kiss on the lips, although I didn't say it was on the lips, but a kiss on the lips might not be sexual contact in some circumstances? Well, interesting question, but I think that's sexual contact. I don't know what else that is. I mean, a kiss on the lips. You say your thought was, that the person gets some kind of gratification, but I don't know in my example that the person didn't get some kind of gratification from the kiss. So I don't know I don't quite know what it means. I feel like that would be importing another level of blurry kind of subjectivity into it. But yeah, I think, so both of you have suggested, so Professor Turkheimer was saying it should be contact with certain parts of the body, and you were importing a different kind of test into it. And sure, you can try to cure the problem in affirmative consent by shrinking the domain of sexual contact. But the problem is in the definition of affirmative consent, because, as I say, it can pick up stuff that's voluntary. And when folks have engaged in sexual contact voluntarily, nobody should say that an assault has been done to them. Just think about that. That's not an assault when you've engaged in sex voluntarily, it seems to me.
The only thing I would say actually goes to a point of agreement. That's regarding the collateral consequences of a conviction for rape or similarly serious sex crimes. I think that there is a need to rethink some of these collateral consequences in the domain of rape. And this is a really important point, right? Because again, we're focusing here on the question of affirmative consent and thinking about substantive statutory reform. But part and parcel of moving forward and thinking about how we want to treat these kinds of cases in the future is, I think, a good hard look at some of the stigmatization, the sex offender registration that has been imposed in a I think cruder way than what we ought to be able to do. And I will just point out that the American Law Institute effort that Professor Rubenfeld mentioned is also taking a good hard look at some of these collateral consequences. And there seems to be widespread consensus that we ought to be ratcheting down some of that. And I want to make that point here too.
All right, I think the next question is for Professor Turkheimer. The question is, you said the burden of proof remains on the state, but it's basically impossible to disprove a negative. And affirmative consent necessarily sets a presumption in favor of the victim. So de facto, the burden is going to shift to the defendant. In reality, the defendant has to show there was consent. Isn't that unfair?
Yeah, I mean, I think the jury charge in the jurisdictions that I've mentioned makes very clear that the burden stays on the prosecution. And in court challenges to suggest otherwise, the courts have made clear that this is not a burden shifting problem. So the prosecution has to prove beyond a reasonable doubt that there was, let's say, penetration without consent, and then the definition of consent is read to the jury. And if the jury finds that that kind of consent wasn't given, right, and the prosecutor has proven that beyond a reasonable doubt, that's a conviction. Otherwise, if that hasn't been proven beyond a reasonable doubt, not guilty, right, as it should be. So it's not a legal burden shifting. You can think of it as in the moment, right? The presumption is if she's doing nothing, right, or if he's doing nothing, that's not consent, right? Absent some sort of indication, earlier indication to the contrary, right? Doing nothing doesn't mean consent. That's the only way in which I see this as, sort of shifting any kind of burden. It's not a legal shifting. It's in the moment of the sexual encounter. What are the sort of presumptions that are being put into place? And again, I'm perfectly comfortable with a framework that says doing nothing doesn't mean consent. You have to indicate some kind of willingness somehow. You don't have to sign a contract. You don't have to say the words, but you have to do something to suggest that this is what you want to do.
May I? Well, we're getting a little bit into the criminal procedure weeds here, but for those that are interested, I do think that the problem's a little bit harder than that. So prosecutor proves penetration, proves sexual intercourse, and let's say kind of rests prosecution's case at that point. So the jury knows proof beyond a reasonable doubt. Let's say that there was proof beyond a reasonable doubt that there was sexual intercourse. Well, if there was only sexual intercourse, then there hasn't been affirmative consent at this point. And if you're a defendant in that case, you got to put before the jury evidence that there was affirmative consent, or you're going to lose. You run the risk of being convicted. If you're a defendant, nothing Professor Turkheimer said was wrong. The jury instructions are going to say that ultimately the burden of proof is on the prosecutor. But if you're the defendant in that case, how are you going to not try to put on evidence? How are you going to not feel that you got to prove that the other person did say stuff? If you're in a state that has an affirmative consent definition, you got to show that you got to show the jury that there was affirmative consent. You better take the stand, which has always been something that defendants weren't supposed to have to do. How else are you going to do it? You better take the stand and say, this is what happened. There were these words or actions that indicated affirmative consent. Now, that's not required because Professor Turkheimer is technically correct, but boy, is there practical pressure on defendant to make that showing himself or in the unusual case, herself, and to take the stand to do so.
Yeah, I mean, in a case where there's not affirmative consent in place and she testifies that she said no, right? Let's say the defendant has an option. He can cross-examine her and leave it at that, or he can take the stand. I'm not sure that the difference in an affirmative consent jurisdiction in terms of the defendant's imperatives change all that dramatically.
All right, here's a question for Professor Rubenfeld. You argued that affirmative consent standards would criminalize voluntary conduct, but isn't it really the case that affirmative consent would define voluntary conduct and that would be an appropriate feature of the criminal law?
That's an interesting question. I mean, I don't want to get too much into semantics, but no. I mean, for example, at the hearing that I was describing to you, there was actually a report issued by the hearing panel, unanimous, that the sexual activity that had been engaged in was voluntary. They used that term. It was voluntary, but there hadn't been affirmative consent. And one way to think about that is sometimes affirmative consent is defined as positive, voluntary, unambiguous consent. So what there was lacking in that case was the positive, unambiguous consent, but they found that it was voluntary. And so you can play around with words in various ways, and that's a problem with the law. But I'm talking about the question of whether people did something willingly, whether something was done to them against their will. And folks have sex all the time. People who are married, people who've been in relationships, perfectly voluntarily, not against their will, without saying or doing something that counts as clear, unambiguous, affirmative consent. And if we lose our ability to say that, if we get turned around, twisted up in words, we say, no, it wasn't voluntary because they didn't consent, we will have lost our grip on what sexual assault is supposed to capture, and we'll have lost our grip on common sense. Talking about voluntary activity in the common sense use of the word, nothing was done to anybody against their will, but there wasn't the verbal or clear enough conduct expressing affirmative consent. And those are the cases that I was describing.
Right. I think this is a question for Professor Turkheimer, and it's gotten lots of thumbs up on our computer screen here. If two people are equally intoxicated and engage in sexual activity, how can you sort out who's the victim and who's the aggressor?
Yeah, I can see why you all like that question. That's
This is a law school hypothetical. It never comes up on our college campus anyway, so.
Yeah, so intoxication on both sides, and we hear a lot about that, particularly when campus sexual assault comes up, right? That seems to be kind of the paradigm that people have in their heads, and and there's some reason to believe that there is intoxication on both sides in many cases on campus. Not sure if most is the accurate description, but many, and so as a criminal law matter, how would those cases be resolved? First of all, you've got to think about the evidence that would prove that one or the other party was the assaulter, right? And in the scenario, I can't remember the wording of the question exactly, but what you seem to have described, the questioner seems to have described a scenario where neither party would be able to describe with any sort of coherence what happened, right? And so if the question is, how do you then sort out what to do with that case? My intuition is to say there would be no ability to sort that out without a witness who had the wherewithal to know what happened and the ability to recount with some specificity and precision, which is what prosecutors need to move forward with a case. You don't have a case. Now, could you posit that scenario with some corroborative evidence that one party was the aggressor and was taking advantage of a vulnerable victim? Yeah, you could imagine somebody, for instance, videotaping all of this, right? And so you might have a camera that showed that one party was clearly acting in a more predatory way. But I gather from the question that that's not what you have in mind. You have in mind two very intoxicated people, and nobody really knows what's going on, and maybe neither party is behaving in ways that are all that clear and unambiguous. And in that situation, you say maybe are both parties guilty of sexual assault, or is neither party? And what I say is, in that case, the criminal law cannot move forward with respect to either one.
Well, I don't know why it couldn't. I think it's a great question, and I think it's a real problem from an affirmative consent point of view. There are a lot of people who believe in affirmative consent measures who think that a sufficient degree of intoxication, short of total unconscious incapacitation, renders a person unable to give a valid affirmative consent. In those cases, it's easy to imagine both parties being intoxicated and being unable to give affirmative consent that way. Over half of college undergraduates say that within the last 4 weeks they've had sexual intercourse. Of those who say they have had sexual intercourse, over half of them say that they've had it while intoxicated. And so there's a lot of it going on. And if both people are intoxicated, then both are sexually assaulting the other. And I don't know why the law couldn't proceed. It would be, if the law didn't proceed, it would be once again an embarrassment to the law. The law is describing something, it's saying this is sexual assault, and then the law doesn't go forward. That's not the way the law is supposed to work, and people aren't supposed to be sexually assaulting each other in one transaction. It's a very strange result.
I think it is important to distinguish between intoxication that leads to impaired judgment, right, which is not what I've been talking about, and then intoxication which gives rise to some sort of incapacity to communicate, right, which might implicate affirmative consent. But in a case where you've got two intoxicated individuals who are engaging in affirmatively consensual sexual activities and then after the fact feel as if they were too intoxicated to have made good decisions, that's not a case that I would want to be captured by the criminal law, and that's not the affirmative consent standard that I've been advocating.
Can I just say one more thing about that? Well, I just agree once again with everything Professor Turkheimer said, and so if I was misattributing a view to you, sorry about that. So I completely agree with that. it sounds like there's a lot more agreement between us on these intoxication cases than I realized. And I think we both further agree that if people are incapacitated, that is, they can't speak, or they can't stand, or they don't know what's going on, or they can't physically control their body so that they couldn't resist even if they wanted to. If you can't control your body, if you can't speak, if you don't know what's happening, you are incapacitated. If somebody has sexual intercourse with you under those circumstances, you are the victim of a sexual assault, you're the victim of rape. That's true already in every state in the country. You don't need affirmative consent measures to get to that. Do you know a Title IX coordinator? Title IX is the law that applies to this stuff on college campuses. A Title IX coordinator at Duke was asked this question about what happens if two students are intoxicated, not incapacitated, but just drunk, intoxicated, had a few drinks. Are both, because this person had taken the position that if you're intoxicated, you cannot validly consent. This Title IX coordinator had, and someone asked him, well, then if two people are intoxicated, are they both raping? Are they both sexually assaulting each other? And the answer that this Title IX coordinator gave, and you can find it, you can find this online, the coordinator said, in that case, the man has to get the consent from the woman. And if I had a son, I'd give him that same advice. Like I get it, I understand it. That should be that he should be getting the consent. I'm not against it as a cultural matter. It's like the advice I'd give a son if I had one. But that can't be the law, can it? Like, how did that happen? Like, what is there a gender bias now in the law? So now that's not something Professor Turkheimer said. She didn't say that or suggest in any way. But that's how, in some places, this is playing out.
All right, we have a question now for Professor Rubenfeld. The role of the law is as a mechanism of social construction, and our society institutes laws to try to alter common actions towards a more desirable end. Doesn't affirmative consent evolve societal understanding of intimacy? So people engage in affirmative consent as second nature, and wouldn't that be a good thing?
That is such a great question. There were some fancy words in there, but I'm sure everybody understood the question. I'm going to rephrase it. Look, Professor, you're kind of analyzing it from a legal point of view. What affirmative consent measures are really all about is changing the culture of sexual relations in a way that some people think is desirable. Not everybody thinks it's desirable. Do we want to appoint institutional masters to change sexual culture in a way that some people think is desirable and other people don't? But I'm going to skip that question. Let's say you think that's a desirable cultural change. Let's just say you do. Let's just say whoever's asking the question is in favor of that cultural change. They'd like to see it happen, and they want to use the law to make cultural change happen. Well, there are certain ways that I think it's okay to use the law to make cultural change happen. One thing is, taking the word law a little bit broadly, if college campuses want to change sexual culture, and that's what they're using affirmative consent for, if they're not like a state university, if they're private actors, they have that authority. They can do it. But don't keep calling it sexual assault, and remember this debate is about importing that into criminal law. So I think the questioner has just suggested the best possible defense of affirmative consent measures on college campuses. The person says, yeah, they agree with everything I said, but we want to change the culture. That's what we're doing. We're willing to have, some problems until we get the culture changed. But don't do that with criminal law. Don't label people sexual assailants. Don't label them sexual offenders. Don't use the criminal law if what you're trying to do is you think that there's a better way for sexual intimacy to unfold and you'd like to see more of your preferred culture for that. That's, in my mind, a very dubious use of the criminal law.
Well, I agree that the criminal law cannot get too far out ahead of social consensus around these issues. I absolutely agree, and I think that's a really important point. The criminal law can lead, but not by too much, right? And there's a really interesting relationship between law and social change that, at least to my mind, suggests that there's got to be a fairly close alignment between the two, right? Again, if the criminal law is too far out ahead of what our society generally believes is acceptable, appropriate behavior, we have a problem. I think with regard to affirmative consent, we've reached the point where we've got some pretty good consensus on this. And if I'm right about that, then the criminal law really ought to go ahead and adopt these standards into a criminal code. We're heading there, in my view, no matter what. We're going to get there. It's a question of when, and it may be that this is the time.
All right, I think this is a question for Professor Turkheimer. How long does consent last? What if a couple establishes consent and then one partner fails to continue to consent? Is the other partner automatically guilty of criminal behavior in view of those changed circumstances?
Yeah, I mean, I think the idea is that consent is ongoing, and that if at any point in the course of a sexual encounter, a party decides that he or she no longer wants to engage in the behavior or doesn't want the behavior to escalate, right? It's perfectly acceptable for that person to stop consenting, right? We do that all the time. So, I think generally the standard in place in those jurisdictions that have affirmative consent rules tends to work pretty well in giving the jury a workable framework for evaluating the question of, when does consent end? How far does it extend? There's not going to be a cookbook. There's not going to be sort of a recipe that easily gives rise to these conclusions. But with regard to sexual assault cases, these determinations are never easy, right? This is complicated, and it's what we ask juries to do. I think we give them the right framework when we ask them to consider whether at every stage in the sexual interaction, each party has indicated a willingness to continue with it.
All right, I think we have time for one last question, and of course our visitors are from out of state, and it wouldn't be a Utah debate if at some point in the debate we didn't have a question about guns. And so this is for both of our speakers here, and I think the gist of it is, well, if there's somebody who has a concealed firearm, which is permitted under Utah law in many circumstances, how would that play into this? Would there be some obligation to disclose that someone has a firearm as part of gaining sexual intimacy? If there's no duty to disclose, how are the parties protected from misunderstanding? The question, by the way, I'm asking this question because you selected it as the top choice question with 19 likes, and so there are 19 people sitting on the edge of their seats waiting to find out what our panelists have as the answer for that.
I can definitely say I never thought about that question before. That's the first question I got in a long time that I had never thought of before. I got to say that requiring the disclosure of that concealed firearm, mixing that with, I'm just not really sure how I feel about mixing guns and sex. I just think I just think that's a thorny problem I'm not prepared to answer right now.
Yeah, I'm also a little flummoxed by the question. I think maybe it raises for me sort of a set of issues that are apart from the affirmative consent question. I think that if there's a gun in the mix, it's unlikely that any kind of consent that's given is going to be sort of free, and so I'm not sure that the real conundrum is whether the consent is affirmatively given, right? But whether there is freely given consent in the presence of a firearm.
Well, I'm having fun with all the features here of this electronic questioning. You could see I could determine what the most desired question to have answered was. And it says there's a poll feature here. So it looks like if I push the poll, I'll be able to find out who won tonight's debate. But
you told us you weren't going to do that, Professor Casella.
Well, I know that I don't need to push the feature because I know the answer to that question. And the winner of the debate, of course, is all of us here in the room, because we've come to hear two very excellent speakers enlighten us on that fact. So I want to thank again our speakers for informing us about these issues, and I think they could say a few minutes. If I know I didn't have a chance to ask everyone's questions, so if you'd like to talk to our speakers afterwards, I'm sure they'd be glad to stay a few minutes. Thanks very much for coming this evening. That was good. I think it worked well, and it was kind of fun to question. So
I really did not understand.